So, if someone is a provisional taxpayer, like as in they legit meet the tax definition of a provisional taxpayer, then they cannot, by definition, be subject to auto assessment either. So, because remember, provisional taxpayer is yeah, but again, because there was a follow up question said had similar problems, mostly with logbooks that are denied. But remember, a person with an allowance should not be auto assessed. So if we go back and look at who should be auto assessed, your auto assessed persons should be someone with straight remuneration. We're not talking commissions, okay? But it's a straight salary. Your investment returns are below the prov tax threshold, so below the 30,000, and that's it. So the concern I have is that if you are ending up in a situation where someone who should not have been auto-assessed in the first place was auto-assessed, then right. And I will be the first person to admit that as much as I love e-filing, it doesn't work perfectly. So my bigger issue here isn't the fact that there is to look at the fact that was the auto assessment correct in the first place, rather than contend that is this fair? No. Okay, right. I'm 100% in agreement that for someone who's a commission earner, where there's deductibility of expenses and the rest, that this is a problem. Unfortunately, um, the issue that we have is that we need to make sure that we're objecting in the right way. And my objection here would have been number one, there should have been a request for extension, or alternatively, before the 40-day timeline was up, it should have been an objection based off the fact that this person didn't actually qualify for auto assessment. The problem that we have at this point is the fact that there is a little bit more leeway in the law, giving SARS the right to auto assess and then tell us to get knotted, than there is for us to go and say, but you assessed incorrectly in the first place and therefore get your assessment overturned. So we are at a practical disadvantage. And so what I would also go with at this point is to go and say, if SARS at this point has incorrectly auto-assessed someone because they didn't actually meet the criteria and SARS is not working with you, this is something you need to take to your RCB, because they are the ones who are best suited and best situated to go and have a conversation with SARS over a table with someone who's at a senior enough level to actually go and address the systemic issue, to say, right, how do we fix this in future? If you have someone who was correctly auto-assessed, but they missed some medical expenses, for example, and the taxpayer didn't meet the 40 days deadline. Unfortunately, at that point, there is very little that we can do legally from that point of view, because of the fact that we were given a time frame to respond. The fact that the taxpayer didn't respond is technically not. They were advised of their rights and their obligations. And as much as we can go to SARS and go and say, guys, this auto assessment is wrong, please fix. Per the Tax Administration Act, legally SARS is within their rights to say no. This is one where we need to manage and walk the line with client expectations very carefully with respect to what is actually possible and what is not. Okay. Can the tax ombudsman help? That honestly is going to depend on your exact circumstances, because remember, the tax ombudsman is not going to look at issues where SARS has actually met their procedural timeframes. You didn't. So they may not necessarily be able to help you in this case. Okay.